Respondent number 2, mentioning on behalf of Tubuko answer.
Item 14.
Item number 14. Is
This is for order. Let us see what it has been listed for. For what it has been listed?
Lordship, and item 15 and 16, the updated CD has been called for.
Hmm?
Updated CD has been called for in item.
Okay. It is connected.
Actually, Lordship, the item number 14 is not connected with 15 and 16. Item 15 and 16 are corrected items.
But it is with.
Wrongly reflected, Lordship. That's why, Lordship, I am praying for.
So that is why.
I am praying for splitting this item 14 and
Okay.
14 from 15 and 16, Lordship. Since in all matters, the learned senior counsel PJ Serke is appearing. So on last occasion, it was wrongly mentioning for listing together, Lordship. It was mentioning for listing together on same date, but it was wrongly tagged, Lordship.
It's criminal petition.
Lordship. Two different FIRs, Lordship.
Okay.
Both
Mr.
are different
Yeah.
PS cases.
Okay. So item 14, who is for the, you are for?
I'm for respondent number 2.
Respondent number 2.
Yes, private respondent number 2 in item.
You have
number
no
14.
objection with
No,
item 14. Okay.
no, Lordship.
Mr.
Keado.
Learned Counsel, submit that the conducting counsel, Mr. S. Koyang, Learned Counsel for the respondent. Respondent?
Yes. Private respondent number is there, Lordship.
There is private respondent here.
Complainant,
Private,
Lordship.
yes, private respondent number 2 in item number.
Just a minute, I thought this is joint petition. It's not a joint petition.
No, Lordship.
Okay, okay.
We are challenging the criminal proceeding on merit, Lordship.
Mhm. Okay. Respondent number 2 submits that and prays for adjournment of the matter on the ground that Mr. S. Koyang is out of station,
Yes, sir.
to which Mr. K. Lolin, Learned Counsel for the petitioner, has no objection. Accordingly, the prayer is allowed. List this matter after
Can it be, Lordship? May I humbly pray for fixed date, 24, Lordship.
24.
After break, Lordship.
Okay, 24 July. It's Friday.
Yes.
On Friday,
Yes, Lordship. Or Lordship, can it be on 31? 24 or
24. Okay.
and there is an interim order, Lordship, that may be.
Stop. Para. The interim order passed earlier shall continue till the next date of listing. Okay.
And Lordship, the item number 15.
Okay.
and
The
16,
it is actually not connected.
Not
Not connected means nowhere is in other case whether has it been clubbed.
yes, there was an order. It was
Okay.
wrongly mentioned, Lordship.
It is some in the before that it is submitted that the item number 15 and 16 are not connected with the present petition. Therefore, however, in which item it was pass for clubbing together.
My lord, in item number
In the-
40,
14.
In
order dated
14,
40. Order dated 24,
Yes.
2026.
24, 2026.
item 14,
Yes,
there is no order. 24,
24, Lords,
2000.
26.
No, I couldn't see the order.
Then item
It's
15,
19.3, then thereafter 25.5. There is no order pass on 24. It must be in summary.
then Lordship, item 15 on 21 for, I think, Lordship.
In view of the above submission, the item number 15, 15, 16 otherwise is connected.
Connected, Lordship.
Okay, 15, 16. And this item 14 is detached from the item 15 and 16. Okay,
Lordship. And Lordship, this item 15 and 16 may be again listed on 24 because the senior counsel will appear in 3 cases.
okay. As a for respondent or
I am for petitioner, Lordship.
no, the senior counsel will appear for the petitioner.
Petitioner.
Okay. Then item 15 and 16. Mr. K. Lolen, land counsel for the petitioner submitted in the instant case. Is senior Mr. Vijay Sakya. Land senior counsel will appear on behalf of the petitioner. And therefore he prays that the matter may be listed on 24. The prayer not being objected to by the respondent is allowed. Stop accordingly list the matter on 24th. Okay.
Lordship, in 15, 16, there is no respondent, only PP, Lordship.
There is no respondent. PP. Okay.
And Lordship, there is an interim order that
The
may
interim order pass earlier shall continue till then. Okay.
be obliged.
Obliged.
My lord, I beg to mention item number 6 and 7, my lord. In 6, I'm on behalf of the applicant, and in 7, I'm representing respondent number
And
Fine.
6 you are for?
for applicant, my lord.
Okay. In 7,
7, I'm respondent number 5.
what do you want?
My lord, the senior counsel is out of stations. I pray for the adjournment.
Who is for the respondent?
Sir, I'm respondent for numbers, item number 6 and 7.
Okay, you are for respondent.
Yes, sir.
You have no objection.
Your lordship, counsel kindly pray for continue of the interim order.
Okay. But adjournment, you have no problem.
No, sir.
Okay. Miss
KIO,
Land Council submitted his senior Mr. R. Sona, Land Council for the petitioner. He is out of station, therefore. She prays for adjournment, to which Miss,
Yes.
good name,
Nabam Rima.
Land Council appearing on behalf of the respondent has no objection. Prayer allowed. When do you want?
Counsel kindly,
after vacations, my lord.
Okay, as prayed for, comma, list the matter after the ensuing summer vacation. Where the interim is, in which case? In which
My
case
lord,
there is interim?
There's in both case, there is a interim order.
In both
In,
cases?
Item number 6, it's in my favor, and item number 7, and it's favor on the applicant. my
Okay,
lord.
how? Just a minute, huh? 6 is against 7. 7
Yes, my lord.
is against 6. There
Yes,
is
my lord.
stay in both.
My lord, in 6, in item number 6, my lord, I challenge the WS in learned CZM code, which is the first order to the file the WS.
Are you sure there is interim order?
Not interim order. I think here is in
In item 6, there is interim. The
Yes.
interim order passed earlier
interim
shall
order.
continue
My lord.
till the next date of listing. In 7 also there is, I think, similar, huh? Same,
Yes, my lord.
no problem, no. In the interim order, if any, comma, shall continue till the next date of listing. Okay, list is matter after the ensuing summer vacation on a date to be, date to be fixed by the registry. Okay.
Problem, my lord.
Lordship, I'd like to mention
Okay.
one criminal petition number 46 to be taken tomorrow, Lordship.
Hmm?
I'd like to mention, Lordship, one criminal petition to be taken tomorrow, Lordship.
Tomorrow.
Lordship, because this is will be led by the senior advocate from Guwahati. He's
Tomorrow is DB day. How many matters are fixed?
Single bench, 7 matters are there.
7 matter already. We do not know how long the DB will sit.
Lordship, but we'll look into the situation, Lordship.
Hmm?
Lordship, if there is a time available, then we'll,
Then only.
Lordship.
Okay, is the last item. Okay.
Okay.
What is this matter about, by the way?
This is for discussing of the FIR.
Okay.
Item number 1,
Lordship, I'm for the petitioner,
Yes.
and as for the last order dated
Hmm.
12/6/2026,
Last order date.
yes, Your Honor.
Okay, why it has notice not issued?
Notice steps has been taken.
Notice was already issued. Why it
Yes.
has been listed again in the motion column? Notice already issued, it appears.
Yes,
You have taken steps also.
yes, Your Honor.
Why it has been listed in the motion column? Should have been in the order. Your correspondent,
Yes, Your Lordship.
whether any request? No,
I'm only for one.
I think mistakenly listed in the motion column.
It
isn't
seems, Your Lordship.
Uh,
It seems so, Your Lordship.
Not, it appears the notice already issued.
It may be wrongly is
Okay, so what is to be done here? Service report is awaited in respect of respondent number 2. Who is this respondent number 2?
It's a Gangura Association,
Gangbura Association.
president of the all
Mm.
Gambura Association.
customary court. Your Lordship.
Which item we are talking about? It's a name. And Nera, President Ol Sagari. It's a name of the person who is the president.
Yes, Your
It's implicated in the implicated the person, it's implicated to the person only, not the association. It's not the association represented by Mr. So-and-so, but it is Mr. So-and-so. It's a private respondent only. Isn't it?
Yes, Your Lordship. It seems, Your Lordship.
3 is also. 3, you are for Mr. You are for
One, Your Lordship.
1, and then what about the respondent number? It appears that respondent number 3 received. Service awaited in respect of respondent number 2 only, it says. And who is this 3? 3 is the private. Okay. Anyone appears on behalf of respondent number 3? No.
No.
Have you taken steps upon the respondent number 3 as well?
No, Lordship.
No. Then you take steps. The 3 is concerned party. Any order pass will affect the respondent number 3 only. You take steps.
Lordship.
What is this case about?
Basically, they are challenging the order of the Gangura Association. Your Lordship. If Your Lordship will turn to page number 25, Your Lordship. This was the initial order.
Hmm?
Page number 25, Your Lordship.
Page number 25 is,
Yes, annexures 4.
well, why in the civil revision petition, there is a substantial question of law?
No, Your Lordship, this was the initial order. It was by the inter-village customary code. Then again,
Oh, no, I'm saying that in the petition, there is a substantial question of law. How many substantial questions of law? I think,
6 and 9.
we all need to learn.
Yes.
This is in the civil revision petition, you have set out the, how many substantial question of
9,
law?
Your Lordship.
Hmm?
9, Your Lordship.
9 substantial question of law. When we are confused, we should consult the senior, part with some of the fee, some amount of fees. Then we will learn. Hmm?
Look.
And then, in order to maintain the quality of the, petition. That will invest in knowledge. Okay, anyway. That's why it has been listed for motion. What happened there? Is it you who argued earlier?
Senior,
Yes, okay.
yes,
Where is he?
he's here.
Hmm?
Here it's a.
Where? Okay,
Your Honor, this case is challenging the order passed by the Intervillage Sub-Division Customary Court Associations, as they have not followed the proper procedure of law. Because the respondent number 3 has filed complaint before the Intervillage Customary Court Sagali. And thereafter, what happened? This the respondent number 3 filed the appeal before the Additional Deputy Commissioner Sagali. And then Additional Deputy Commissioner Sagali remanded it to the All Sagali Subdivisional Customary Court Association, which is not the appropriate
okay.
format.
According to you, this customary court who passed the impugned order has no jurisdiction,
Yes,
according to you. Anyway, but then why substantial question of law?
they have,
Anyway, but then you have not taken steps upon respondent number 3.
no, we have taken. We have taken upon the
No, but
respondent,
it's not on record.
but we have taken upon the respondent number 3 also, my lord.
No, not on record. On record is only upon respondent number 2.
My lord, as per the order dated 12, last order, it is period 9, issue notice to respondent number 2 returnable and so and so that. But we have taken a respondent number 3 also.
There is not reflected, the office note doesn't reflect that. It's only reflect that the petitioner has taken steps upon the respondent number 2
Okay, then,
on so and so.
okay, then my
And
lord,
the next is that service is awaited in respect of respondent number 2. It is only with regards to respondent number 2. You take steps upon respondent number 3 also?
Okay.
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 Mr.
and Talim,
Learning counsel for the petitioner submits that inadvertently he could not take steps upon the respondent number 2, 3.
Three.
Stop. Therefore, he prays that he may be allowed a granted 3 days time to take steps upon the respondent. The office note, respondent number 3, stop, the prayer is allowed. The office note dated 23/6/2026, 26 also reflect that notice upon the respondent number 2 is still awaited. Stop. In view of the above, list this matter after 3 weeks. Stop. Mr. Rira, for respondent, government advocate is present on behalf of the respondent number and the state respondent. Stop. Okay. after 3 weeks. Huh? You take
Problem.
steps within 3 days.
It's
Okay.
interim order earlier on, interim order may be helpful.
The interim order passed earlier shall continue till the next date of listing. How the interim order is helping you, by the way?
This the all Sagali subdivisional customary court
No, no.
is set
This
aside
is regarding what? Child custody.
child custody.
Have you filed any guardianship or custody?
No, I am a father.
Your father?
Yes,
What is the age of the child?
child is 6 years.
6
No.
years,
9 years.
9 years.
Yes, and child is comfortable staying with me, and the child is recently get admissions
Now, by the impugn order, child has been given to whom?
to the respondent number 3 mother.
Mother.
Yes,
So you have not yet handed over to mother.
child is refused to go with the mother, and child is comfortable with the father.
Mother says child is comfortable with mother.
Yes, no father. Yes, petitioner is the father,
Okay.
and the child is presently with my custody, and now he's got enrolled admission, school admission in my village.
In the, is a hosteler? Where?
No, the
From-
school.
Home.
From home on. Because my child is refused to go with the mother. That is the issue.
Okay. The interim order passed earlier shall continue till the next date of listing.
Much obliged.
Item number 2,
May I please, Your Lordship?
Yes.
Lordship, before coming to the main point, the Kaupura, the village authority of Papumpare district needs more awareness, It's because they are trespassing the provision is the capability in the provision, the Civil Code Act, as well as the AFR, Assam Frontier Administration of Justice. Clear definition is given. Still then, the association, this president of the Kitanagar Capital Complex and all, they are exercising the jurisdiction of the village authority, which is not as per the provision. So therefore, this is the same case where complaint has been lodged before the president, Itanagar Capital Complex. And on receipt of the such complaint, again, Gaupura of the different village, issued the impugn summons to me, So therefore, I am agree by the impugn summon issued by the Gaupura, the village authority of the different village, other village. I have categorically mentioned if Lordship peruse the first of all complaint and except for page number 29. And here, the complainant is my younger brother, and the petitioner is younger sister, Oh, sorry, elder sister.
I thought both are younger. Who is the elder?
Page, and except for page number 29 is the make complaint lodged by my brother against me,
Against you?
Against me,
Okay, your sister.
Yes, I am elder sister, And the president, Itanagar Capital Complex, Itanagar Capital Region Gaupura Association,
Okay.
This complaint has been lodged to the
No,
Gaupura
no,
Association, And acting upon this, this summon, impugn order, the page number 28, and except 3, impugn summon, This has been issued by Lordship will find,
Page
first,
28.
find, it is in the name of the intra-village territorial customary code of Itanagar Capital Complex. And again issued by the if Lordship see the person who has issued GV so and so circle Naharlagan so and so they are not at all having jurisdictions to issue. I am belongs to Borum village, and my brother is also residing there permanently. Presently, permanently, they are from the Borum village only. We are residing within the. So they have
Police
no,
notice?
yes, my lord.
Ah,
In the
yes,
meantime, my lord,
Jikato. Land counsel for the petitioner. Mkato, huh? Sorry, land counsel for the petitioner. Para. The petitioner, by filing this application under Article 227 of the Constitution of India, read with section 115 of the Code of Civil Procedure 1908, has challenged the
impugn someone, my lord.
summon
That no
Stroke.
order, my lord.
stroke
Only date.
mail order dated when it 17
17/6.
17/6/2026. Issued by the so this is issued by GB Circle Nahalagan,
My lord.
but then in the
Or they have mentioned is inter-village territorial
Mm,
customary code.
by the okay by the Inter Village Territorial Customary Court of Itanagar Capital Region, requiring her to attend the attend the hearing of local customary court to be held on 26
Correct, my lord.
6/2026 at Ama Nursery, Borum Village, Nahalagan. Stop. Para. It is submitted that both the petitioner and the respondent are brother and sister and are residents of Borum Village.
Correct, my lord.
Borum Village. Stop. No, in earlier notice, that is a village, Borum Village, Nahalagan, in connection with, this is connection with,
Same place, my lord, Borum,
no, just a minute. This is for what?
for land dispute, my lord,
For-
between.
In connection with the land dispute. Okay. Thereafter, so the board are resident of Borum Village and the Inter-Village Territorial Customary Court being this is all Arunachal Pradesh Gambura Association.
Yes,
So according to you,
Yep.
who doesn't have the jurisdiction?
only, my lord, the village authority of Borum village.
No, your challenge is that the Inter-Village Territorial Customary Court has no
Authority and
jurisdiction.
jurisdiction, my lord.
Where have you stated? Okay. It is further submitted that the president, the complaint was lodged before the president.
Correct, my lord. President, Itanagar Capital Complex, Gaupura.
Okay, the president, Itanagar Capital Region, Gambura Association,
Yes, sir, reason.
before whom the respondent lodged complaint. Has no jurisdiction. It has no authority under section 5(1) of the AFR 1945 as well as under section 2D of the Arunachal Pradesh Civil Code Act 2021.
Correct.
Is it so?
Yes.
Stop. Issue notice. Returnable by 4 weeks. Stop if they are not authority, record need to be called for, no?
Not required, my lord. It's
Okay.
because no proceeding has been done.
The petitioner shall take steps for notice upon the respondent within 3 days from today.
Madam.
By speed post as well as by usual process within 3 days from today. Stop, para. List is matter. After 4 weeks,
Madam.
stop, para. What else?
Malad interim paper.
Is there any, okay, para. In the meantime, the impugn summon stroke mail order dated 17/6/2026 issued by the Inter-Village Territorial Customary Court of Itanagar Capital Complex shall remain state till the next date of listing. Okay,
Malad. Deep level.
Item number 3,
Malad in other Malad villages, Malad all the other villages, they are complying to the provisions of this Malad particular rate Malad. But then Malad mostly frequent.
okay, how, para, however, it is met, however, no, because this is association only.
Association only.
The authority otherwise not precluded
Yes,
from
madam.
passing any order.
Just for the economic purpose, Malad, I'm just
No, because here they have wrongly, the complainant has wrongly filed the complaint before the association president.
yes.
But then if it is filed before, or if it is endorsed to the GB, or it is filed before the GB,
Malad.
this order will not actually
Yes,
operate.
Malad.
Okay.
Now that will be Malad different putting Malad. But
Okay.
however, Malad, the village authority, what they are doing is Malad, that they are accepting the Malad, the complaint lodged before they Malad. Malad, what they have to do is Malad, they have to Malad return the petition even if it is filed, saying that you go to the Malad, the proper authorities, which is the village authority.
No, in the alternate, what they can do is forward it to the Gambura of the concerned village, forward it.
Forward is
And then the Gambura of the village
Malad.
should issue notice in the name of the Gambura only, not in the name of the president.
No, Malad, nothing.
Not in the name of the
No, no,
association.
only village
Then
authority, Gambura
purpose
head
would have
will be
been
Malad.
served, because
This
in
is
the,
only as per the procedure, Malad.
like zero
Even
FIR.
Malad forwarding is also not Malad in consonance with the provisions, Malad. It can
No,
directly lodge it to the Malad. Therefore, the village authorities, Malad, by Civil Code Act, Malad, Codes
Because,
Act 2021 has been Malad enacted, Malad. Just to Malad the ease the
no, because it's not clear who is the head to whom the complaint should lodge. Supposing in a village, if there is more than one head GB,
head GB, Malad.
yes, head
Then head
GB.
GB, Malad.
If there is more than one head GB,
Yes, Malad.
then whom do this complainant lodge his grievances or lodge his complaint? Then in that case, supposing if in a village, if there is a head
GB, Malad.
GB or the association, even if the association receive,
Malad. Yes, again, association does not have the jurisdiction, Malad.
no,
to
so but he has to endorse. He has to endorse to the concerned GB who has a jurisdiction. And that concerned GB having jurisdiction, like the zero FIR, that he will register and he'll issue notice or summon or parwana in his name, not in the name of association.
Yes, sir.
Okay.
Just for academic purpose.
Yes, yes.
Malad.
Okay. Item 3. Yes,
Lordship, this is a joint application, Lordship.
joint application.
Lordship, filed by the victim as well as informant and then the alleged accused, all alleged. 5 of them, Lordship.
Accused 5 of them.
Lordship. Accused is 2 to 5.
Okay. Let
And
us
the
see
informant and then the victim is 1.
Okay.
Lordship,
What is
basically,
the allegation?
allegation is abduction and
No.
voluntarily causing simple hurt. 323, 365, 447, Lordship.
Just a minute, huh? Okay, the residence. It's abduction.
Abduction.
What is 448?
447, Lordship.
Hmm?
447,
447?
criminal trespass.
48 is also there. Yes, okay.
Lordship,
323,
charge-
342. Oh,
Lordship,
this is IPC.
yes, Lordship.
This is when? 20. Okay,
This is of
2023.
yes.
Okay, so then what happened?
Lordship, charges has already been framed, page
Okay,
51, Lord.
trial
Trial has commenced.
commenced,
And
evidence.
witnesses, most of them has been examined, Lordship. Five out of,
How many of them have been examined? How many remains?
Lordship, I have mentioned, Lordship.
Okay, where? This you have annexed the police statement.
Para 12 I have mentioned, Lordship.
Hmm?
Para 12, Lordship.
What you have said?
Page 12, Lordship, para 12. 6 out of 8 has been examined.
Almost complete.
Almost complete, Lord.
Then in that case,
Lordship, this dispute is arising out of a familial dispute, Lordship.
no, abduction.
Abduction, Lordship, not at all will be attracted,
Hmm?
Lordship. Abduction, here, Lordship, the victim, informant is the brother-in-law of all the alleged accused, Lordship. On the
Victim is father-in-law
brother-in-law,
or brother-in-law.
yes. They are family, in fact. And by relation, all the alleged accused are uncle of the victim and the informant.
What is the last order of the court?
Last page, Lordship, we have annexed in the last page.
Okay.
Page 59.
Why the someone IO. But all the you see the witness almost except for IO, I think. All already recorded. There is material against you.
Lordship, 2 IOs, they have been,
Two IOs,
they are
only
yet
two
to be
IOs.
examined.
All the witnesses have examined then,
Lordship, so
except
why,
for the IO.
Lordship, I'll pray that LCR may be called for as of today.
Yes, Mr. Loy.
Yes, Lordship. This year may be called. However, Lordship, it's appear they are relatives, Lordship. And
Have you annexed any of the deposition?
No, Lordship, I have not.
What happened thereafter?
Lordship, the position, I'm told that most of the witnesses, they have turned hostile.
Hostile.
Yes, I'm
So
told, I've been
then
instructed.
subsequently they have compromised.
Compromise, Lordship. In fact, here the victim
Why the
informant is an practicing advocate, Lordship.
Hmm?
He is a practicing advocate.
Who?
Taniram Minki, Lordship.
Victim.
Victim, yes, victim informant.
Okay, victim is practicing advocate.
Correct. Lordship.
Okay.
Compromise settlement agreement, Lordship will find at page 52, Lordship.
Yes. Miss, what do you say?
Lordship, I have no objection if Lordship, check out Lordship.
No point calling record then in that case. It appears.
As per their statement, all the witnesses are hostile. Lordship.
But then you could have actually annexed at least one or two
Yes, Lordship. In the
evidence which is in your favor,
Correct.
according to you. Could have. Heard Mr. J. Gini, land counsel for the petitioner. Also heard Miss Loy, landed PP for the state. Para. This is application. This application under section 528 of the Bharatiya Nagarik Suraksha Sanhita 2023 has been jointly filed, has been filed jointly by the the victim informant and the accused persons praying for crossing of the GR case number 39/2023 arising out of Sire Oyan Police PS. Where is the PS case?
PS case number 1 of 2023.
Hmm?
1 of 2020.
Where do I find?
FIR number, Lordship. 01. In the course title.
One in the course title. It should be PS case number, huh?
Correct.
1
We have written it as FIR.
stroke 2023 registered under section 448, 323, 342, 34 IPC, huh? Now pending before the Chief Judicial Magistrate,
Correct, Lordship. Chief Judicial
Chief
Magistrate.
Judicial Magistrate,
Pasiga.
Pasigat. Tara. The petitioner number 1, Kaniram Minki, is informant, informant within bracket victim, comma, the petitioner number 2, 3, 4, and 5 are the accused in the aforesaid GR case number 39/2023 arising out of the Sile Oyan PS case number 1/2023. Stop there. The case leading to the filing of this criminal petition is that on, where is the FIR? Okay, on 27/1/2023, the petitioner number 1 lodged a written FIR against the accused persons for forceful abduction, and assault with lathi, punch, and stick, comma, punches and punch and kicks, huh? Based on which the aforesaid Sile Oyan PS case number 1/2023 was registered and arrested the accused persons. Arrested
Since offenses were bailable, they were released on bail from the police.
and subsequently released on bail. Stop. Upon completion of the investigation, comma, the police has laid charge sheet against the accused petitioner number 2 to 5 for the same offense. Stop. The learned Chief Judicial Magistrate took cognizance, comma, and frame charges against the accused petitioner number 2 to 2, 3, 4, and 5 for offense under section 447, 323, and 365 of the Indian Penal Code. And during the trial, 4 prosecution witnesses has already been examined. And now the case is pending trial before the Chief Judicial Magistrate, Pasighat, Staff Para. The learning counsel for the petitioner submits that during the pendency of the trial, the parties being the relatives has resolved the amicably settled the dispute by executing a compromise deed struck settlement agreement dated 13/3/2026, whereby the informant, whereby it is stated that the informant and the accused persons being related, closely related family members, and the informant being the brother-in-law and brother-in-law of the accused persons. Has amicably settled the misunderstanding between them. Stuff. The informant in the said agreement deed, the informant categorically stated that he has no further grievance against the accused petitioner number 2 to 5, and he does not want to pursue with the matter any further. It is further stated that the parties have agreed to cooperate for taking steps for quashing and setting aside of the criminal proceeding pending against accused petitioner number 2 to 5 before the court of the Chief Judicial Magistrate, Pasighat. Stop. The learning counsel for the petitioner further submits that the witnesses so far examined has all turned into hostile. Not turned into, they did not implicate the accused for commission of the alleged offense. Under the circumstances, he submits that there is no scope of conviction in the present case, and And as such, the proceeding of the criminal case against the accused before the before the Court of Chief Judicial Magistrate would cause unnecessary harassment to both the parties and would amount to the abuse of process of law. Therefore, we praise for setting aside and quashing of the aforesaid proceeding against the accused person before the Chief Judicial Magistrate Court Pasighat. Stop para. Mr. Loy, Nane PP, fairly submitted that considering that the informant and the accused persons are relative, being brother-in-law and being father-in-law and brother-in-law, with close related, being brother-in-laws, the accused person being the informant being brother-in-law of all the accused persons. And also considering that the matter has amicably been settled between the parties by executing the compromise deed stroke settlement deed dated 13/3/2026, he has no objection if the prayer of the petitioner for passing the further proceeding of the case against accused petitioner number 2 to 5 is allowed. Stop. I have heard. And my observation, I'll record. Okay. Dispose.
Item number 4.
Yes.
This case I'm challenging an order option passed by the judicial magistrate, UPR option. What's the tally? This is the order passed in the Jimma petition.
It's overpass in Jimma petition.
Yes. Lordship, I'm a stranger to the entire proceeding, Lordship. I'm not an accused, Lordship. I'm a businessman running my business in Dimapur, Lordship. I'm a businessman and I'm running a business in Dimapur.
Dimapur.
Yes, sir. Lordship, you kindly see page number 37. This is the FIR to which everything had happened.
Just a minute,
Yes.
You noticed marketing company.
Yes.
Company.
I'm from Dimapur. I got it. Lordship, there was FIR time before.
Just a minute, sir. Okay. So the
In page number 37, I have the type portion. This is the
page
37.
37.
FIR filed by the respondent number 2. Page number 37, para number 2.
There are two.
Yeah.
37 is FIR.
Yes, that's possible.
It's a very long FIR. Yes.
Just read some portion of it.
Before which police station? Itanagar.
Itanagar. In the
Just a
month
minute.
of June 2024, report by one Harishankar Pandey, who told me that he and his team brokers provide donation to NGO. He further stated that he would get my NGO a donation of rupees 18 crores from a company, out of which I would have to give the company back 12 crores, and rest money could be used by us. At first, I declined to partake in the arrangement, but he insisted and finally relented and asked one of my relatives who run an NGO by the name of Sons Cooperative Society about the same, and the relative agreed to do so. Thus, I agreed to partake with the agreement. In the month of August 2024, Harishankar Pandey came to Itanagar he told us that the company will finance us if and is ready and asked us to for rupees 2,50,000 for paperwork. Accordingly, I transferred to rupees 2,50,000 to the account number of one Kumari Renu, number so on 22/8/2020. He then told us that we have to make a demand draft of rupees 12 crores in the name of Sampat so and so limited HDFC Bank. And once the money is transferred and NOC is obtained, he will collect it in our NQN. The company will give us the demand draft accordingly. However, the money never came to our account. Hence, we got the said demand draft cancelled. He then told us that some technical issues happened and hence the money could not get. Then he left for Varanasi, from where he said he belonged. Again on 22/9/2024, Harishankar Pandey, along with other accomplices who introduced himself as Mahavir Shah, arrived at Itanagar. We booked their tickets, and upon their arrival, they told me that this time they had been given green signal from the company, and hence the representative has also been sent. I was asked, this is important. I was asked to prepare 3 demand drafts of rupees 4 crores 90 lakh demand draft number so and so, dated 25/9/2024 in favor of Nurul Enterprise. Rupees 4 crores 90 lakh by demand draft number so and so, dated 25/9/2024 in the name of IS Soibam Sons, and rupees 2 crores 20 lakhs by demand draft number so and so, dated 25/9/2024 in the name of Jasmine Blackboard. But as I agreed before, the confirmation of the original instrument were to be kept with me, and only on confirmation of the project would the same be handed over to them. Both Mahavir Shah and Harishankar Pandey stayed at Itanagar while the DD was prepared. After preparation of the DD, my staff sent a photo of the DD to Mahavir Shah and asked him to now facilitate the transfer of amount into the NGO account. However, both of them abruptly left on 27/9/2024, with Harishankar Pandey saying that his wife has suffered a heart attack and he had to leave. Since then, they gave the number to another company executive who introduced himself as Prabhakar Tiwari and told us that the money would be credited in a week or so. However, after waiting for last 11 days, no confirmation was received from them. As such, I went to the bank on 5/10/2024 for cancellation of the aforesaid bank draft. But to the shock and surprise, I learned that 2 of the demand draft bearing number so and so has already been withdrawn by them from the bank at Meghalaya and Imphal on 30/9/2024 and 3/10/2024 respectively. I was only able to cancel the draft number so and so. Given the said act, it is now confirmed that either with the connivance of the banking authorities by forging the bank draft, the counterfeited the seal of the bank authorities, the person along with the unknown partner created false document number so and so in favor of IK Soibam Sons, so and give number so and so in favor of Jasmine Blackboard, and use those false documents to show them as genuine to cheat me for an amount of rupees 7 crores 10 lakhs. Now that is the allegation. Now this, Lordship would see, this has been filed by someone called Bengia Yanang, who is the respondent number 2. Now, Lordship, pursuant to this, there was an investigation, Lordship, and on investigation, police found some trace of the amount where it went, Lordship. And then, Lordship, the son of the complainant, that is the respondent number 3, had filed a Zimma petition. And that Zimma petition was allowed. Lordship, may kindly see the Zimma petition orders.
The money was deposited by respondent number 2.
Money, no, Lordship, the demand draft were made by the different respondent number
Respondent number 2. And Zimma application was filed by
3.
3.
Both are different.
Both are different. And what is your problem?
Now, Lordship, I'm coming to that, Lordship. That when the Zimma petition was ordered on page number 27, Lordship, may kindly see the last portion. Page number 27.
Page
And
27.
this quote
Just
is
a minute,
of
just a minute.
opinion,
Just a minute. Huh? Page 27.
page 27. As such, this court is of the considered opinion to direct the concerned bank members to refreeze the account of the accused person and their accomplice, which is not me, and to release the money and remit the same to the account of the applicant, that is Bengia Sunday, who is the respondent number 3. Furnish a copy of the order, and that is of the order dated 10/3/2025. Lordship, after that, what has happened? There was a series of bank accounts. Page number 29.
No, the respondent number 2 is,
2 is the different person, 3 is a different person.
no, 3 is son, 3 is son.
Son of different.
Hmm.
But as per the FIR, demand draft was given by respondent number 2. Now, the order.
In the report of the
Filed
IA,
by
it is stated that
the respondent
applicant
number 3.
under something is the right
Now,
to
after
honor
that,
the problem. So, it was,
It's strange,
the account, your account was freezed.
my account, I am nowhere in the picture, Lordship, not even mine, there are a total of 120. The figure is around. Total, more than one, in my instruction, total 150 bank accounts were seized. Lordship.
Hmm.
And total 150 bank accounts were seized. What happens, Lordship? They are investigating the case as if it's a cyber fraud. Now, what they are trying to say is at one point of time, I received some amount, which is the crime procedure. Now, FIR itself is not that. FIR is that some accused person has defrauded the respondent number 2 by realizing the demand draft. And on that, the bank officials of HDFC Bank were involved. I am maintaining an account in Dimapur Axis Bank branch. I am not even nowhere in the picture. But I'm just giving an example, Lordship. Today, if I steal someone, get some money by executing a false demand draft, I come to somebody X, a person X, and I buy one car. I give the money to the person X. Because my money was stolen money, the X, Lordship, who is not even in the picture, has been, the money has to be returned from X. Lordship, first it has to be decided from the Axis Bank and from me whether that amount which was given by somebody to my account belongs to a crime proceed or not. Without considering that, Lordship,
In the
how
report
could
of the
the
IA,
can be allowed?
in the report, just a minute, the order, you have not read the order.
Or Lordship, I'll just read the order.
Just, the Jacob presents the.
Today, the case is fixed for report and hearing. Learned Counsel Mr. T. Yatso for the applicant is present. Learned TP.
Okay, no need to read that in the report.
In the report of the IO, it is stated that the applicant, Bengia Sunday, is the rightful owner of the frozen amount of rupees 1 crore so and so in the instant case. It is also stated that the forensic and the financial tracking report, that is what I'm trying to say, corroborate that the money in question was unlawfully siphoned off from the applicant's account and investment. It has been siphoned off.
No, the respondent number 2 has had deposited the amount in this account.
No, not sir.
Where?
That if respondent number 2 has executed 3 demand drafts
Okay, but then it was
and it was
credited in the account of,
somebody else, we do not.
okay.
Not somebody has taken the amount. Lordship, can you see the FIR? Again, Lordship. What is the case?
No, just, so,
Page
on what basis the account, this account
they,
was freezed?
exactly, Lordship. They thought that these accounts, some sale proceeds,
How anybody's XYZ account can be freezed without any connection with the
what
case?
what happened? Lordship? They are investigating the case as if it's a cyber fraud. Now, that's why I'm giving an example. Today,
No. So, not example. Let us see the correct picture.
Yeah.
So, why this was freezed, this account, on what basis?
they are trying to say that the accounts which were there, some sale crime proceeds went to that account.
Hmm?
Some sale crime proceeds That means the money which was siphoned off, some portion of the amount went to that bank account. Or my bank account rather.
Okay,
Now, it is the Axis Bank who will say, or me who will say how I got the money. Now, Lordship has to see section 110 of the Evidence Act. I have
so
certain
by what way some amount has gone into your account?
that they have not mentioned. They have just said that Lordship may kindly see the report, Lordship.
Okay, report is also there.
Not the report, what the learned court has mentioned, Lordship.
Mhm.
Lordship, that part. Third paragraph. In the instance case,
Just a minute.
it is
In an instant case, okay, it is also.
it is also stated that the forensic and financial checking report corroborate that the money in question
Hmm,
was unlawfully siphoned off from the applicant's account.
hmm,
Now, who is the applicant? The respondent number 3.
hmm.
Who has given the demand draft? Respondent number 2. Where is from where they are saying so, Lordship?
So forget about that. They are mother and son. Let us come to next.
Yes.
Hmm.
As such, this court is the considered opinion to direct the concerned bank managers to defreeze the account of the accused persons. And
Okay, so when it was free, my question is,
freeze during the investigation process. Lordship.
there was a complaint against you also as well then in that case?
No, that freezing part we do not know. because-
Okay, anyway, but then that will take time. So what we'll do,
Yes.
Your Lordship may call for the TCR as well as the CD,
Yes.
Your Lordship.
charge sheet already submitted,
No, Your Lordship.
then TCR
That's,
were from,
because of the JIMA, Your Lordship, JIMA application.
Okay. okay,
They're
Jima
challenging the
application.
order.
The case is still under investigation.
Yes.
So only the trial court record is to be called for,
Also the CD, Your Lordship,
also CD.
because during the JIMA application, the investigation report was sought from.
Okay. Heard, Mr. Land counsel for the petitioner. Also heard Miss Jeannie. Land additional P before the state. Respondent number 1. Where is the impugn order, you said? What is your prayer? Not be.
And then decide. But I know in the picture. The bank have not stated anything that is equal to my amount in resolving some unjust legal entity. That is not the case of the bank. And that is why the bank has not given any amount in now. Even though the already of the year can be more than 1 month after. Now it is, I have come to know, because of non-compliance of its orders, the bank. is-
Okay. By filing this application under section 528 of the Bharatiya Nagarik Suraksha Samhita BNSS 2023, the petitioner challenges the order dated 10/3/2025 passed by the Learned Court of Judicial Magistrate First Class in JIMA application number 13/25 under section 497, read with section 503 BNSS. Whereby what was the direction?
Turn the money, the account of the
Direction in the impugn order
To defreeze the bank account of the.
to defreeze. To whereby it was directed. The concerned bank manager to defreeze the bank account of the petitioner. Is a petitioner. Bank account of not the petitioner. The account whose account was defreezed belongs to respondent number 3.
I don't know which account it is referring to. Informing 1,075,000.
What company you said? Northeast Marketing Company. Proprietor. Defreeze the bank account
The accused person can direct on this.
of the accused person. See, that is why I'm asking. You said the respondent number 3. It's account, bank account of accused person only. Accused person means you,
No.
means the petitioner, no. So how you are connected then?
From where the money will be, benefit to the account. That simply comes to know that my account will, from my account, or the case and amount of this 10 lakh to be given to the account. And that is why I'm telling you.
Where is that?
Your lordship will find that at page
What is my name is referred to
19.
19.
No, you are agreed by this impugn order. And in the impugn order, it is mentioned that it's accused. And you said that you are not the accused.
Yeah, referring to here. All these bank accounts belong to some accomplice. They think that I'm
And the account of the accomplice in the list of money and remit the same into the account of the canceling investment. Defreeze the account of the accused and their accomplices and to release the money and remit the same into the account of the petitioner number 3. What is that?
not too bad. For all our
What is this? What is this page 29? What is this page 29?
So it has been given a report given to the report by the police. The SI Samuel so investigation officer.
Just a minute. Okay. Issue notice. Since Miss Jeannie accept notice on behalf of the respondent number, state respondent number 1, no formal notice is required to be issued to the said respondent. However, the petitioner has to take steps for service of notice upon the rest of the respondents by speed post as well as by usual process within 3 days from today. Stop. Para. Hold for the file code record from the record of GMA. It's only GMA
Only
application.
Jima.
A record of GMA application number 1325 under section 497 rated section 503 BNSS from the Land Court of Judicial Magistrate First Class as well as the scan copy of is in both the scan copy only
Yes.
scan copy of the case diary of EWS case number 183 2024. So list this matter when
Your lordship. On 20, your lordship, आज कितना है? 24 ना? On 3rd of July, Your Lordship.
3rd of July, okay. 3rd is a Friday.
No, after 13th हम लोग का vacation
Okay, okay. After vacation. Yes. When? After vacation, when?
on 20, Your Lordship.
20? Okay. Okay,
On 20, election petition is there.
okay, 21.
21.
Okay. 21 or 22 also election petition.
No, Lordship.
Okay, 22. 22 is Wednesday.
Lordship.
The-
Okay. What interim? You said that you, now how do we separate? How do we pass order? Your accounting is also not there. You are nowhere there. Page 29.
The undersigned was following the terms of the by the respondent by the recent dated first class. The complex issue against state by in respect of bank as a nature of unprofitable compliance to Gavi the transfer of chosen amount and case compulsory. That despite the lapse of the said security period, the enforcement government has not been complied with and the amount continues to remain further in the said act. The non-compliance of the report by of the specifications that detailed communication has been made to the concerned banks for the direction of the report in unacceptable. It is therefore communicated in the report that takes fancy anything once then and she leave to. So that the direction should not.
Hey, this whole thing happened more than 1 year, almost 2 years back. Now you are claiming. How the any action, any action taken person to the impugn or direction shall be subject to the outcome of this this case. Okay. Way back, 25, more than 1 year, almost 2 years. Now you are. The bank has come to know. So it was not forwarded to the bank, the order.
The bank is not a case bank. Now I am a businessman and I am doing myself. The banking also said that is my account service. Now suddenly something comes because of an audit of 1 year back, I have to give 10 back. My knowledge also.
Before passing order, probably notice must have been issued. Okay. Okay, it is account only, subject to the outcome, no problem.
Item number 5.
Yes. Join application. Applicant number 1 is accused. Application petitioner 1 is accused. Petitioner number 2 is father of the deceased. 3 complainant. Let us see the allegation. Immediately brought to the hospital. Hello? So what happened thereafter? Criminal case registered? Charge sheet filed under 304A. What happened, and then what happened to the, did he pay compensation? Hmm? Oh, 8 June. What is the condition? Page number? Sarah? Hmm. All the medical expenses. When this was executed? When the incident took place? 23. Medical expenses of what? Whom? Hmm? You said that this is died in the accident. What medical expenses? Okay, okay. The first hospital. No. No, this is, no. When the victim died? 3 months. Now after the incident in the 2023. Now in 26, you are saying that he will bear the medical expenses and shall also the party shall refer to the victim in the best hospital in 2026. He died 3 years back. How do I understand? I don't know, but then you have written this, that the first party shall bear all the medical expenses to the victim as a matter of compensation. I could understand only that what is written by you. The first party shall refer the victim in the best hospital of the Dibrugarh, Guwahati, TRIMS. The person died 2023. Now you are saying in 2026.
Your Lordship, with regard to that, at serial number 1, in the first line, it's written, Your Lordship, that on
That on,
dated 6/11/2023 during the.
but this is the condition in the earlier.
Yes, there was a meeting, it seems. This was the
Oh, the
condition
hell.
proposed.
Residents of the board. Oh, this is oral, both the parties with certain terms and conditions. Okay, then what, have you complied with? Then why you have referred this? It said that the first party has paid all the medical. You should have referred this. You show the judge this line and ask me to understand something else. Paid all the medical expenses for the treatment of the victim. Shall come with the family of the second party. But unfortunately, after 3 months. That's okay. Then where is the condition that you have fulfilled? After that, after he expired. Where are you reading? Hmm. Help them for medical expenses. That is done. Now what? Not compensated. We may have to call for the record.
Your Lordship, I'll just,
What is the status of the case?
Your Lordship, I'll just place certain objection with regard to this, Your Lordship. A coordinate bench of this honorable court had dealt with this same type of case where the death was caused due to rational negligence. Your Lordship.
Mhm.
Now coming, if I may place the order, Your Lordship. I was the additional PP in this particular case, Your Lordship. Now, there was another case by the coordinate bench of this honorable court in Ojing Darin case where this matter under the settlement in rational negligence, a death on rational negligence case was allowed, Your Lordship, quashed. This was also placed before this bench of
Mhm.
Justice Kalita, Your Lordship.
Mhm.
That was also referred to, and subsequently the Lakshmi Narayan case as well as Gyan Singh, Daksaben case were also taken into consideration. Your Lordship will come to page number 14, Your Lordship, paragraph 19.
Hmm?
Page number 14, paragraph 19, Your Lordship.
Yes.
Now, the court, after deliberating on all the judgments of the apex court as well as of this honorable court, had come to this conclusion, if I may read so, Your Lordship,
Mhm.
paragraph 19. Coming back to the facts of the instance case, in the instant case, the victim died because of rash and negligent driving by the petitioner number 1 and 2, and subsequently due to monetary consideration as compensation, the helpless wife and family members of the victim had agreed to compromise with the petitioner numbers 1 and 2 and to settle the entire dispute in private agreement. From the aforesaid case law that have been discussed, one of the most important aspects which emerges is that in case of compromise, a compromise is basically with the victim and accused offender. Therefore, the principle is basically to the effect that victim does not have any grievance against the accused offender. But in a case of death resultant from rash and negligent driving, the victim is no longer there to say anything about the grievance or non-grievance. Therefore, the compromise between the informant or the family members of the victim and the accused offender cannot be said to be a compromise on the basis of foundational principle that has evolved, while various judicial pronouncement. Another important factor which needs to be considered is the cascading effect of rash and negligence driving in public at large. It is also observed that in many of the cases of the rash and negligent driving, the cases have been compromised by settlement by paying money as compensation before an FIR is being got. By this type of compromise, what actually seems to have been done is that certain rich people are settling those cases by paying certain amounts to the poor victims' family. By doing such acts, what actually is being done is that the rich people are buying the criminal elements from the poor victim, and criminal jurisprudence in India is not to be so, as the criminal justice system in India is based on the concept of state versus the accused and not between the private individuals. In the case decided by Punjab and Haryana High Court, Baldev Singh versus State of Punjab and another pass in so-and-so decided on 2/6/26/16, the same issue of compromise in a case under section 106(1) of BNSS cropped in, wherein the Honorable Punjab and Haryana Court has negated the prayer of quashing of the case on the basis of a compromise settlement between the family of the victim and the accused. It has also been discussed about the dangerous precedent that would be laid if certain offenders are allowed to go scot-free with the so-called compromise settlement with the victim's family, wherein the victim herself is not present to consent. This will clearly go against the criminal jurisprudence of this country. In the view of the aforesaid, this court is of the considered view that in instant case in hand, the plenary power under section 528 of the BNS cannot be exercised. Now, this is an absolute case, Your Lordship. Your Lordship, as has discussed in this particular case, Your Lordship, whenever a settlement is being made, Your Lordship, the settlement, more particularly, there is no provision of settlement under any act, Your Lordship.
it has come with a judicial pronouncement that non-compoundable cases can be settled, Your Lordship. Now, basically in settlement, Your Lordship, as has been discussed in this particular case, Your Lordship, the settlement is always between the victim and the accused. Now, when the cases come up, when the case is registered, it's always between the state and the accused, Your Lordship. However, when the compromise comes, it's between the victim and the accused, Your Lordship. Now, when the victim is no more, Your Lordship, any representative cannot make a compromise or settlement with the accused and invoke the inherent power of the court for quashing, Your Lordship.
It was rejected.
Yes, it was rejected, Your Lordship. Also, the court has taken into
So according
consideration.
to you, notice also not
Yes.
deserve to be issued.
Yes, if Your Lordship consider, since,
Let us see.
yes, Your Lord.
What is the progress of the trial? That is why I'm asking. We'll call for the record.
Yes, sir.
Okay, hard, Mr. Learned counsel for the petition. Also, hard, Ms. Jeannie, Learned Edison PP for the state. This is an application filed under section 528 of the Bharatiya Nagarik Suraksha Sanhita 2023, praying for quashing and setting aside the charge sheet number 15/2025 under section 279, 338, 304A IPC arising out of a fire dated 7/11/2023 in Alo Police Station case number 67/2023. In which court it is pending?
CGM Alo, Your Lord.
Okay, stop. Issue notice. Since Ms. Jenny appears on behalf, appear and accept a notice on behalf of the state respondent, no formal notice need be issued. Start. Call for the scan copy of the trial court record. Stop. List this matter. After.
After vacation, Your Lordship.
After.
On 23rd, Your Lord.
Richard, let us see that. Let us see. Okay, we'll take break of 4 minutes.
Item number 8.
Yes. Second appeal. What is that? Okay, this annexure 17 passes what order? Page 274. What order was passed? Okay, then what jurisdiction error has committed? By not considering, by not condoning the delay? Yeah, if not explained, then the magistrate or who passed order? District judge. Yes. So what jurisdictional error has been committed by rejecting your delay condonation petition? Yes, it has to be in technical only. So that that means you have a right to cause delay or make delay. Then that is why I'm saying there is what he has exercised his discretion, and he was according to him sufficient cause was not shown. There are 12 of What is that? Hmm. See, but no such environment. You should have explained the day-to-day delay. If not explained, then how if not explained or without explanation given, how do you expect the judge to consider? Para? 6. No, you said that fairly, you also admitted. Hmm. Yes, on your fault, the order was passed on being admitted. Then my question is, what jurisdictional error has been committed there? Okay. Will issue notice? Okay, on this, what is the substantial question? Is this substantial question? A. What is this? Heard, Mr. Current counsel for the petitioner. Appellant. This appeal under section 100 read with order 40, Roman 42. No, yes, Roman 42 of the Code of Civil Procedure 1908 is directed against the order dated 27 5 2026 passed by the Land Court of District Judge Council in KSA stroke IA within bracket J number 08/2025 in KSA stroke title appeal number 04/2025. Whereby the delay condonation application application for delay, application for condonation of delay of how many days you say? 167 days. In filing, in preferring the connected appeal has been dismissed. Dismissed?
Yes.
Stop, huh? Issue notice. Will not admit immediately. Will just issue notice. Okay, issue notice. Returnable by 4 weeks. How many respondents are there? The petitioner, the appellant shall take steps for notice upon the respondent number. Respondent, sole respondent by a speed post as well as by usual process within 3 days from today. Stop, huh? List this matter. No. Call for the record need to be called for. Call for the scanned copy of the trial court record. Scanned copy or the original? Okay. Okay, thereby your delay, if delay was not condoned, your appeal also dismissed. Okay, now whereby the application for condonation of delay of 167 days in preferring the connected appeal along with the appeal number along with the title along with the KSA title appeal number 04/2025 came to be dismissed. Staff, issue notice, huh? The rest will is same, huh? Now, if it is dismissed, now in the interim, how it is already dismissed. We'll see. See, the appeal has already been dismissed. Now we'll see and pass necessary order after record. Okay. List this matter immediately after receipt of the record. Okay. On the date to be fixed by the registry. Okay.
Item number 9.
My lord, this is yesterday's matter, my lord. The necessary correction has been done, my lord.
Where is the, just a minute, the applicant in the earlier, okay, he has left. There was a decree. Any execution petition filed? Okay, then it's no problem. Okay. Yes. No. There, if there was a decree earlier, this was appeal. Appeal was dismissed. In the decree, if the execution petition has already been filed, execution proceeding, if it is proceeding, then if you pray for the stay of the execution proceeding, that's different. That is, I just wanted to ensure. Okay, that's fine now. Okay.
Yet they're challenging the conviction and the sentencing order, my lord. Now,
Just a minute. Item 9.
yes, my lord. Day before yesterday, my lord, the matter was called for, my lord, but then they did not challenge the sentencing order, my lord.
Okay.
Therefore, that has been amended, my lord. Now they have challenged it, my lord.
So now they have challenged.
Yes, my lord.
Next further on the top. Question B, next further.
Annexed what order? Sentence order also.
I think figure please.
5 years. This is in admission. Okay. Item 9. Okay. I didn't see, huh? It was yesterday. Okay, withdrawn. Will admit?
My lord.
Okay, hard, Mr. Vijamo. Land counsel for the appellant. Also heard Mr. Opada. Learned standing counsel. ACB. It is only ACB. State is also there.
Yes, my lord. The
No, state is not there. It's SIC again.
ACB.
Okay, there is a private respondent.
Yes, my lord. He is informant, my lord.
Para. This criminal appeal. This is this appeal, huh? Criminal appeal under section 4152 of the Bharatiya Nagarik Suraksha Sanhita 2023. Is directed against the judgment and order dated 7/5/2026 passed by the Learned Special Judge Prevention of Corruption Act UPA in PCA case number 01/2012 in SIC within bracket VIZ capital, huh? Bracket close PS case number 01/12 under section 409 IPC read with section 13(1)(c) and 13(2) of PCA 1988, whereby the appellant has been convicted for offense under section 409 of Indian Penal Code. The appellant has also challenged the order dated 14/5/2026, whereby he has been sentenced to undergo rigorous imprisonment for 5 years for offense under section 409 IPC. Start. the issue notice, huh? Since Mr. Opada, Land Standing Council, SCB has accepted notice on behalf of the state respondent number 1. No formal notice is required to be sent to the said respondent. Staff, however, the appellant shall take step for notice upon the respondent number 2 by a registered post, not registered, it's a speed post, as well as by usual process within a week from today. Staff, call for. Will admit.
Yes, my lord. We can
Okay,
admit that. In
the
the
appeal is
meantime,
admitted, huh?
trial court report may be called.
Call for the trial court record. Stop, huh? List the matter after receipt of the trial court record.
My lord.
Okay. He has been taken under custody. 7/5. Then total, how long he has been inside? Since earlier also at the time of investigation also he was arrested. Okay. Then you be there for some time. Huh. Why transfer to Jang? It was not required at all. He was working as what? It was not required at all, Jang. The Jang and in Itanagar is altogether different address. Jang is there, we know. But the offense remained the same. 2011 or today. Okay, hard, Mr. Vijamo, Land Council for the applicant. Also hard, same, huh? Mr. Opada, Land Standing Council for ACB, staff para. This is an application filed under section 430 of the Bharatiya Nagarik Suraksha Sanhita 2023, praying for suspension of the sentence imposed upon the convict stroke appellant. By judgment and order dated 7. No, just a minute, huh? Just a minute, huh? Leave that, huh? It is submitted that the convict the appellant in 16 AP, criminal appeal 16 AP 2026 has been convicted for offense. Has been convicted, huh? Just a minute, huh? it is submitted by an order dated, just by judgment and order dated 7/5/2026. The appellant in so and so criminal appeal number so and so has been convicted convicted by the special judge, same as earlier, special judge PC Act. Where PC Act where? UPA for in PCA number 01/2012 in SICVG VIGPS case number so and so, same, for offense under section 409 and sentence, and by an order dated 14/5/2026 sentenced him to undergo rigorous imprisonment for 5 years. Stop. By filing this application under section 430 of the Bharatiya Nagrik Suraksha Sanhita, the appellant is praying for suspension of the said sentence imposed upon the convict appellant. Stop. It is submitted that, what is your submission for this? You said? That is on merit only. Merit, you have already been convicted. Since the appeal filed by the petitioner has already been admitted, and considering that the the convict is a sole breadwinner and also considering the fact and circumstances, considering the contention made in the memo of appeal and submission made by the learned counsel for the parties, the sentence of sentence of the appellant, which is to be stayed, the judgment, the order, the conviction order dated 7/5/2026, and the sentencing order dated 14/5/2026, passed by the Land Special Judge PCX UPA, Kapumpara District, UPA, in PCA number 01/2012 in SICV PS case number 01/2012. What is your submission, by the way?
Yes, my lord.
What is his age? Okay.
My lord, it seems, my lord, the appeal will take some time, my lord. The records.
And also, okay, in the above one more, and also considering that the appeal would take some time to dispose of, okay, the judge sentence against the accused dated so and so, and the judgment and order dated 7/5/2025, and the impugn sentencing order dated 14/5/2025 so and so, shall remain suspended. Till the next date of listing.
No, once it is suspended, my lord.
Till the further order?
Yes, my lord.
Okay,
Because once it is suspended,
till further order, subject to the following condition. We'll put the condition
my lord,
that we shall execute a bond, how many would do, how much will do?
50,000.
Bond of rupees 50,000,
Like that.
which 50, on execution of a bond of rupees 50,000 with two surety
My-
of like amount, one of which shall be the resident of Arunachal.
Can be, my lord.
Because he has already been convicted. Yeah, that is why. He is under suspension now, terminated or what? Okay, so
It will be deep suspended.
hmm,
Now, whether.
much earlier.
Yeah.
It was done.
That's
Now he is no longer in.
convicted, my lord.
Hmm?
He
That is
just-
why I'm saying.
Therefore, my lord,
Hmm.
automatically he'll be suspended, my lord.
Mhm.
So whether the suspension will be revoked or not.
No, that is why he need to be ensured.
My lord.
That what other condition is required?
Since he's a government servant, my lord, there is no flight as of now, my lord.
Mhm.
Because he has to come back to job, my lord. If he's 52 years old, my lord.
Okay, then okay. No any other condition.
No, my lord, surety will do, my lord,
Okay.
since being a government servant.
Then this stand disposed.
Yes, my lord. Once it is, sentence is,
Hmm.
my lord, it can be disposed of.
Okay, then it will make it till the disposal of the appeal.
My lord.
Okay. With above this. Higher stands disposal. Okay.
Deeply obliged.
Item number 10.
This is criminal petition. Communicate to the. And this.
Lordship, similar to the item number 6, Lordship. Arrest in negligence, Lordship. Arrest in negligence, Lordship.
Okay.
Since Lordship has already gone through the judgment rendered by the Lordship coordinate bench, Lordship. There cannot be a
Okay, same.
Yes, Lordship. There cannot
Okay.
be settlement, Lordship. And
What-
here his basic ground is Lordship on settlement. Lordship, Lordship may kindly come to the page number 29, Lordship. His prayer, Lordship.
So since the settlement cannot be done because the victim is no more,
Lordship.
and then the family cannot settle.
Yes, Lordship.
Please.
Page 29, Lordship.
Have we called for the record?
Yes, Lordship.
The record is available.
Yes, record is available, Lordship.
Page 20, page 20.
29, Lordship. His prayer, Lordship, his prayer was basically on the settlement, Lordship. That's why.
Okay, settlement, based on the settlement.
Yes, Lordship.
He is seeking quashing.
Yes, Lordship.
Pleading also? Oh, married, okay. Just a minute, just a minute. What is the status of the case?
Since Lordship,
Trial.
no CCTV footage, Lordship, near the PO, Lordship, and no eyewitness was there, Lordship. And the MBI report says there is a less effective brake, Lordship, in his vehicle, Lordship.
Okay, because of brake failure.
Oh, yes, sudden less effective brake, Lordship. It's as per the MBI report, Lordship.
Okay. Now, when the incident took place, accident,
On
2026, or charge is filed,
not yet.
this is case,
Not
okay.
filed.
let the investigation complete, let him.
Instead, because FIR, the petition number two, is the informant who were the in charge of the labor. And these two labor, they were writing on file without having it. And they collided with this petition number car. And after that collision, one got severe injury and subsequently this petitioner took them to the hospital. And later on.
See, now this is a case of death. The case is still under investigation. Let the investigation complete. We do not know what will come out.
There are around 15 cases.
I think it will be difficult.
So, it is relating to the internal society. And there was, because facts and circumstances and allegations are different. So that I will say that case, the concern, they refer the case in another case, based on their only, it was not found. Since in that case, why it was not that hard? Because the infrastructure of that disease approached the High Court based on the settlement. And Honorable High Court has settled that part that matter. Meanwhile, why did right? So the Honorable Supreme Court by stating that I am the defendant and I need to be implicated in this case. And there is no any settlement with me. So that's the reason that case was that Honorable Supreme Court has been that way. So that was regarding 306 of IPC. And now my case is 281106 of PLSS that it's
Equivalent to 304A.
yes. And Honorable Lordship also was cases and apart from prevailing for the papers of course of voice around 7 cases by this forum. Even in same circumstances of Meghalaya High Court also, recent cases, and Honorable Delhi High Court also. And apart from that, I have 15 cases to rely into the negligence. Apart from that, denials too. So there is no grants here. But in that certain case, it's referred with item number 6. It was with related to the abandonment of suicide. So there was a suicide note. There was a money foundation. That's the reason is and apart from that, initially that was twice, but later on, wife stated that I need to be my part changes. So that's the reason that that was was set aside by the
What the IO says, how long it will take
Lordship,
to
it is
complete
almost-
investigation?
It is almost completed, Lordship.
Let the charges submit. If they find,
Apparently,
now at the edge of now, it is said that no eyewitness, no CCTV footage also could be
Yes,
found out.
Lordship.
Now, under the circumstances, probably it will be difficult for him also to prove case against you beyond reasonable doubt. But then let us see, let the investigation be complete. Let us see the result because ultimately, see, after all, one person died out of your accident. We do not know whose wrong it was. So let us wait for some time.
Lordship, I'm fairly submitting, Lordship. It's a good case, Lordship, since there is no eyewitness, no CCTV footage, Lordship.
No enmity.
No enmity. But Lordship, as per Lordship, this order, Lordship, earlier Lordship, this coordinated bench order, there cannot be a settlement. That's where, and he's
No. So
basically
let the investigation complete.
Yes, Lordship.
And let us see if there is nothing at all. No? If the mechanical defect or anything found.
Yes, Lordship.
So if that is proved,
Yes.
so let us see.
Yes, Lordship.
Or what?
Well, Lordship, this may be disposed of, Lordship.
With what?
Since such sheet was not submitted, Lordship.
Okay.
On trial, he may be acquitted, Lordship.
Now we cannot come into that conclusion now. at this stage. That is what I'm saying. So it's too early. So on that ground only it will be disposed of.
If settlement and everything is over, yeah. With pairs, basically with the promises. But here, it's not exactly like it, but here, in this, as with the report and everything, and the vehicle there, the vehicle is found down, and the incident happened.
Now see, in this case, it has rightly observed that supposing in this case, okay, let us assume that there was no intention. But then if there was an intention in this case also, if that is, let us assume, and then he happened to be one targeted one by somebody, what then?
That's it. But
Hmm.
that's-
Hmm.
it's either-
Whether by payment of some compensation to the family survive, will it resolve the matter? Will the justice prevail? No. So let us see, let us not come into that sudden conclusion. Tomorrow, anything will happen with anybody. Let us say, take it in the broad way, that it is likely to there may be targeted also. Few years back, some targeted, it was a vehicle only, but then ultimately it was targeted. So someone take the responsibility of hitting, but then the person who target is somebody else who pays. And then because they knows that for accident punishment is lesser, instead of hiring the person, isn't it? Instead of entering into the conspiracy, the accident is easier course. So that is also possible. So considering that, let us see, we'll dispose of this saying that it's too early. Let the investigation be complete, or you want this matter to be kept pending till the submission of the charge sheet? Okay, Mr. Okay. Approach again, because after filing of charge sheet, your prayer also will have to be changed only, ultimately. Or you withdraw just with liberty to file a press, or dismissed, saying that it's too early.
As per the
Now, in that case, you have to file again, impugning the charge sheet. Okay, Mr. Hard, Mr. Tiki Palani, counsel for the petitioner, Mr. Lloyd and PP for the state submits that the case is still under investigation. The investigation of the case is at just a minute, huh?
As per the lordship report, the investigation is substantially completed, Lord.
Submits that the investigation of the case is substantially completed and the charge sheet will be submitted very soon. In view of the above, submits that the matter may be listed. And the charge sheet is on the way, okay?
Lord.
Will be submitted within very soon, okay? Therefore, he submits that the matter may be placed after the submission of the charge sheet. Stop, huh? The prayer is allowed. List his matter. After,
After break, lordship.
okay, after 4 weeks, okay, on the date to be fixed by the registry, okay.
Deeply.
Item number 11.
Yes. Okay. Okay. What has been taken? Okay.
In fact, lordship, item number 11 is in process, lordship, since the accused applicant was arrested, lordship.
Already arrested?
Already arrested, but the item number 12 is lordship still.
So this has become infractuous. If the person has already been arrested, so now it's of no use Do you have the copy of the arrest?
Yes, Lordship.
Okay, please. Okay. Miss? Miss? Yes, your good name, please. Please try. Your name is there? Land Council for the, Land Council appearing on behalf. Okay. Tapu, Land Council for the petitioner. Also heard Mr. Loy, Land PP for the state.
Lordship, by one brother.
Lordship, I'm for complaining, Lordship.
You are for
Complaining, informant,
informant. And Mr.
K Mega Lordship.
for the informant. Stop. By placing. This is a communication or what?
Status report.
Okay. Mr. Loy Lanika, PP, submits that he has received a status report of the case. Stop as per, and as per the status report dated 22 June 6, 2026, the accused applicant has already been arrested in connection with the ALO. What CW ALO? In connection with, okay, ALO PS case number 2026 under section 61 1 316 2 318 4 336 3 338 342 BNS. And thus and since the accused applicant has already been arrested, the matter has become in progress. This is a status report or this just communication to?
In the last document, CD was called for Lordship.
CD was called. CD is there? No.
Lordship, I didn't go through Lordship with CD or it communication, Lordship.
Oh, this is addressed to you only.
Yes.
This is communication, not the as by the communication datedly. Right, huh? In view of the above, this bail application is close on becoming infructuous. Okay? Yes. Next, 12, you are seeking adjournment.
Yes.
12 is different case, I think.
Not same connection, but in this case, the applicant was not arrested, Lordship.
Not yet arrested. Okay, Miss her name, huh? Land Council for the Land Council appearing on behalf of Mr. T. Topu, Land Council for the petitioner. So, you are seeking adjournment for what purpose? What is the ground for adjournment? Topu is,
My lord, the conducting council is out of
okay,
station.
Mr. Topu is, Mr. Submit that Mr. Topu, Miss so-and-so, Land Council submits that the conducting council, Mr. T. Topu, is out of station, therefore pray for adjournment of the matter, to which Mr. Mr. Loy and Mr. So-and-so, Land Council appearing on behalf of the respondent has no objection. Accordingly, the prayer is allowed. Stably, prayed for. When do you want this matter to be listed?
listed after 1 week.
Okay, let's pray for comma list this matter after a week. Okay,
On first of.
1st of July. After a week, we say, okay, on a date to be fixed by the registry. Okay. Okay,
Much apply.
just a minute, huh? Other matter, because petition is for the evidence or what?
No.
Okay, not, no, okay.
Yes. Item
Yes.
number 18,
Item
number 18.
18.
Here
Yes.
I'm the petitioner. Here in the case, in the last time we have called for CD,
Mhm.
case diary, but not the CD is not come.
Okay, not produced.
So
So
it may be fixed after 1 week.
after a week, okay.
After a week.
Mr.
And
Mok Pating, Lada Senior Counsel, assisted by Mr. You are assisted by,
item number 20,
no, just a minute. Let us finish the 18 first.
yes.
Who is assisting you? Okay, Ms. Dirilo. Lana Counsel for the petitioner. So, Ms. Riram, Mr. Riram?
No, Your Lordship, I'm not.
No, okay. Case diary was called for.
Yes,
The
CD
case
was
diary
called
is called for. Is still awaited. In view of the above, and is prayed for by the Lana Council, Lana Senior Council, let this matter be listed after a week.
Yes.
Okay.
And
Okay,
item
done.
number
Item 20.
20,
Uh,
this is for hearing.
okay.
The opponent, the present petitioner of the review petition
Hmm.
is absent.
Okay. Absent.
So this
Yes,
may
Your
also
Lordship.
be fixed.
I'm appearing on behalf of Mr. Estapin, Your Lordship.
Okay, he appearing. So he's seeking adjournment.
I'm also seeking for adjournment.
Adjournment.
Yes, Your
Yes.
Lordship.
Okay.
May it be fixed on 26th.
Monday,
Or
Okay,
Monday.
on the prayer of both the Lana Council for the petitioner and the respondent, let this matter be listed
Monday, Your Lordship.
when? Give the date
29.
Monday? Is there too much a fixed matter?
29, no.
When do you want? Your convenient date? 30?
Your Lordship, 30, Mr. Estapin will be having some difficulties, Your Lordship.
Okay, then after that also,
Can it be any date between 1 and 3, Your Lordship?
1 and 3?
Yes, Your Lordship.
Then let it be on, 1 is
Wednesday, Lordship.
Wednesday.
election petition is there?
What? It is there, Lordship.
Okay, evidence. Okay,
Yes, Lordship. It's for evidence, Lordship.
evidence.
One.
Then it will be 2 at 2. On 2, okay? Okay,
Yes,
2,
Your Lordship.
2 July, 2nd July.
Obliged, Your Lordship.
Okay. We'll continue at 2. Yes,
I'd like to mention item number 17.
Finding. Okay, हम इसको proceeding मार दें.
May I please, Your Lordship? Sorry to interrupt, Your Lordship, but I'd like to mention one item, Lordship. Item number 21, Lordship.
item 21.
Lordship, yes.
Okay.
Lordship, I'm praying for an adjournment for today, Lordship.
Hmm?
I'm praying for an adjournment for today, Lordship. Can it be on 27th of July,
27th of July.
Lordship?
You are for?
I'm for appealing, Lordship.
appellant. Have you informed the other side?
Yes, Lordship. Yeah.
Okay, Mr.
El Sanctum.
Land Council for the appellant. Prays for adjournment of the matter to be listed on 27, to which Mr. Land Council appearing on behalf of the respondent has no objection. Prayer allowed. Listed accordingly on 27th. Okay.
Lordship, I'd like to mention item number 17,
Yes.
seeking for adjournment today.
Okay. So,
I've consented other party as well,
okay, you are for
petitioner.
petitioner. Mr.
Tinima.
Planning Council for the applicant with the consent of Planning Council for the respondent. Prays for adjournment of the matter for,
24 July.
okay, and to be listed on 24th of July.
Yeah.
Just first. Okay. The prayer is allowed. The prayer.
On
Okay.
behalf of Tita.
And pray for adjournment, huh? Of the matter to be, and request to list the matter on 24, to which Mr. Sibo, Planning Council for the appearing on behalf of the respondent has no objection. Prayer allowed. List it accordingly on 24.
24/7.
Okay.
Obliged.
Fabulous.
May it please, Your Lordship.
Yes.
Your Lordship, item number 90, my lord. My lord, this
19.
item number 90, my lord. My lord, here in this case, the notice was issued to the respondent as well as, my lord, the record was called for, my lord. As for the office note, my lord, the TC had not been received and service has already been taken by the petitioner. So, my lord, this matter may be taken up on, my lord, Wednesday on 1st of July, my lord. This case is pertaining to modification of the bail order, my lord.
Okay. Heard Mr. B. Picha, Planning Council for the petitioner, Mr. Also Mr. Peter, Land Edison PP for the state, the trial court record. Trial court record.
Yes, is not awaited.
Is still awaited in view of the above. Let this matter be listed on
1st of July, my lord.
1st July. Okay.
Yes, ma'am. Obliged, ma'am.
Item number 13,
Yes.
May it please, Your Lordship.
Yes, sir.